Hello, my name's Olurotimi Osha. Today I'm going to be talking about aspects of the biased jury instructions by Montgomery County Circuit Court Judge Michael McAuliffe, which enabled him to coerce the jury into manufacturing a wrongful guilty verdict. In my trial was between August the 3rd and August the 6th. 2026. The jury deliberated for 2 days. So they came with just one guilty verdict and two mistrials, two hung juries, right? For the same intent to frighten assault. I've talked about how the judge and the jury ended up coming up with this bizarre perversion of justice, clearly a miscarriage of justice, that the police officer who shot me in the head, who had no arrest warrant, who used racial slurs on me, I'm a law-abiding American citizen, I was in my home, there was no arrest warrant, no probable cause, that somehow I frightened him, right? And they found me guilty. So it was sort of adding insult to injury. He was one of three police officers who tasered me 5 times, no arrest warrant, no notice. They had falsely imprisoned me in my home based on a swatting hoax, right? A fabricated emergency petition which they gave no notice of, right? So they came to inveigle an arrest. There was no arrest warrant for me. An emergency evaluation petition is not an arrest warrant. But by the way, the judge suppressed evidence of this emergency evaluation petition, which was fabricated. It's been discredited. Even the person who swore the perjured emergency evaluation and fabricated all the information in it and misrepresented himself as my uncle. My family, of course, filed a complaint against him in Nigeria because my family is in Nigeria. But saying this man did it maliciously, and he's not my uncle. But despite all of that, the police officers who tased me and the specific one who shot me in the head, right, and almost killed me, admitted his intent was to kill me. I was found guilty of wrongfully frightening him. So it's called, the classification is intent to frighten assault. It's a specific intent crime. It's a second-degree assault, and it's a misdemeanor, but it carries a maximum penalty of 10 years in prison. But because of Judge Michael McAuliffe's numerous reversible errors and apparent judicial misconduct, and which is what I'm going to demonstrate by these series of videos, on appeal, because I retain my right of appeal. Upon appeal, a higher court automatically reverses the wrongful conviction due to structural error. One of the instances of structural error is, of course, the fact that I had no counsel. The judge coerced me against my will, under duress, to go pro se, but I maintained through objections and motions I filed that I was not knowingly, intelligently, or voluntarily giving up my absolute right to the assistance of counsel, right? So I was coerced to proceed pro se. On the day I went to trial, I actually thought that he would answer my appeal to the court's inherent authority to appoint me counsel. He refused, right? And even though I was indigent, I couldn't afford an attorney, he forced me to go pro se. But that's not what I'm going to focus on today. I want to focus on another thing that was a structural error, and on appeal as well is reversible. The guilty verdict on appeal to a higher court automatically reverses the wrongful guilty conviction due to this structural error, and that's the biased and faulty jury and improper jury instructions given by Judge Michael McAuliffe to the jurors. So I'm going to just get into it, and I'm focusing on just the jury instructions. So in the jury instructions, after the the prosecution and the defense. I was pro se, I was the defense, I represented myself. After the end of the evidence and whatnot, the judge gives jury instructions to the jurors after he's discussed them with the prosecution and the defense first of all, right? And so I raised objections to the faulty jury instructions. So the jury instructions are based on three types of laws. One, there are procedural laws, then there are substantive laws, and then there are standards of proof, right? So the procedural laws deal with how the jury assesses the evidence, right, and the credibility of the witnesses, right, during the trial, how they evaluate the credibility of witnesses and the different types of evidence presented to them at trial. So that's the procedural laws of the aspect of the jury instructions. Then there's the substantive laws. The substantive laws deal with the defenses, right? The proposed defenses that are raised by the defendant, right? To address the charges, right? To address the charges, to negate the charges, the defenses against the charges. And then, of course, they also consider the elements of the crime, right? The elements of the crime, the elements of the charges, the features of the charges. And then the standard of proof, that's the standard that will be used to evaluate the laws and the evidence that so in a criminal case, in this case, it's proof beyond a reasonable doubt. The burden of proof is on the prosecution. The prosecutor is the one who has to show all the elements of the crime exist and prove beyond a reasonable doubt to the jurors. The jurors have to be convinced that the prosecution have made their case, proven their case beyond a reasonable doubt before they can return a guilty verdict, right? So those are the types of laws within the jury instructions. Now, on the issue of elements of the crime, right? Features of the crime. The crime was intent to frighten, a second-degree assault. It's a misdemeanor, but unfortunately, it carries a maximum penalty of 10 years in Maryland. So intent to frighten, it's not a battery. No battery occurred. It's just, as it sounds, intent to frighten. The victim was scared. But let me just state what the elements are. So there are 4 elements to intent to frighten, which is a specific intent crime. It's a specific intent crime. So one of the errors that the judge made, and it was intentional because he's a judge, right? He knows that intent to frighten assault is actually a specific intent crime in Maryland. It's not a general intent crime, but he misrepresented it, he and the prosecution. And I raised an objection. I said, no, it's intent to frighten, but he said that no, that it's a general intent to frighten. It's a general intent crime in Maryland and not a specific intent crime. So he misled the jurors in order to lower, to dilute the burden of proof which the prosecution had. And I will get into that, the difference between specific intent and general intent. But right now, let me just itemize the elements of intent to frighten, right? And the judge left out one of them. So there are 4 elements of intent to frighten. So the first is that the defendant made a threatening act, right? A threatening act with the specific intent, right, to put the victim, right, or a person in fear of imminent bodily harm or offensive contact, that they were going to hit them, put them in fear. So it's specific intent, right? So there's an intent element, right? It's right there. Specific intent. That's element number one. The second element is that the defendant had apparent ability to carry out that offensive contact, the bodily harm. They had the apparent ability to do it, and it was imminent, immediate. They had the apparent ability to immediately carry out that harmful contact. The third is that the victim, the alleged victim, right, in this case the police officers, right, had reasonable fear that an offensive bodily harm would occur, right? And it was imminent, it was immediate, that there was an imminent offensive bodily harm that would happen, and it's reasonable. It's a reasonable objective fear, right? It's not them just saying, well, they were in fear for their lives, right? It has to be reasonable. It has to be objective, that we can see that it's imminent, it's objective, right? So it's 40 cops pointing guns at me, right? 40 cops. These police officers, the one that the jurors returned a guilty verdict for, is an ex-Marine, ex-Navy, right? So they're trained killers, right? They're Marines, right? They're all taller than me, all larger than me. They had guns. I didn't have a gun, right? So it's not likely. But anyway, the fourth element is that there was no legal. My conduct had no legal justification, right? There was no justification in the law for my conduct, right? So the judge in his jury instructions left out that fourth element, right? Legal justification. Now, I had a legal justification in that self-defense. I was in my home. The state of Maryland gives me self-defense, entitles me to, allows me to have. The state of Maryland in the law says that I have a right to self-defense in my home under the Castle Doctrine, or defense of habitation, right? So long as I'm not the initiator of the aggressive act, right? So the police had falsely imprisoned me in my home. I didn't initiate aggression, right? And so I feared imminent bodily harm or death from unlawful intruders. The police officers had no arrest warrant. There was no arrest or search warrant. There was no probable cause. So I had a legal defense. So the judge left that out. So that's the elements of the crime. Now, in terms of the defenses, right? So I'm entitled to defenses, right? That's the substantive aspect of the law, as I stated earlier. After the prosecution provides their evidence, I'm entitled to my own defense, and I established so many defenses. Of course, one of the defenses that I had is self-defense, Castle Doctrine. It's an absolute and complete defense in the state of Maryland, right? I'm in my home. I'm not in somebody else's house. I'm in my home. The law in Maryland says I'm entitled to self-defense if I fear, the threat of bodily harm or imminent death, right? That there's an unlawful intruder. I didn't invite the police, right? An unlawful intruder, they've come to my home, and they have no warrants, especially if the police, it's a warrantless intrusion. The police don't have any warrant, right? So the law in Maryland says that even up to deadly force, I'm entitled to self-defense. So that's a legal justification. So all the elements of intent to frighten crime were not satisfied. So you can see it was clearly a wrongful guilty verdict based on the flawed, faulty jury instructions provided by Judge Michael McAuliffe. Now, again, in terms of the defenses, like I said, he didn't allow any defenses, right? He didn't put any defenses in the jury instructions, none whatsoever. Even though I presented my case from August the 3rd, August the 4th, August the 5th, he gave no defenses. I gave the defense of self-defense and Castle Doctrine. I put it in several motions that I've been writing since November 16, 2023. I put it in a motion to him, and I stated it during the trial, right? Of course, he was trying to silence me, saying I shouldn't talk about the law, right? that he would discuss the law later on, that what I should just discuss is I just state the facts. I stated the facts. I was not the aggressor. I was in my home. I feared for my life. I feared that they were coming, so people from outside were coming to kill me. I talked about how I called my friend and I told my friend all my equipment had been hacked. My phone, my computer, everything was hacked. So I had a right to self-defense because I feared imminent bodily harm from an unlawful intruder or death, right? So that's a defense. The judge removed it. It negates intent to frighten assault. It negates the intent, right? The other thing is, so it's a complete defense to intent to frighten assault. The other defense that I raised that the judge excluded was mistake of fact. In fact, the bulk of my defenses, my arguments in case trial was that I was demonstrating that I was under the misapprehension that I was undergoing a test, right? Because I was scheduled for a test by the Navy General Officers Professionals Program. I had an email. I showed it to the judge. The judge didn't let me show it as evidence to the jurors. But I'm going to do another video discussing how Judge Michael McAuliffe wrongfully suppressed exculpatory evidence, right? Due to his bias, and as he was showing partiality, he was showing favoritism for the prosecution in order to manufacture a wrongful guilty verdict. So so he was just presenting a one-sided, he allowed only a one-sided presentation of evidence. That's just the state's presentation, right? Even though they didn't even present sufficient evidence to lead a reasonable jurors to come out with to conclude with a guilty verdict, right? So these jurors clearly were not reasonable. They were rigged. There's evidence that the jury pool was rigged, that the jurors were rigged, right? And I discussed that in another video. But back to the faulty jury instructions by Judge Michael McAuliffe, which led to a manufactured guilty verdict, violating my right to a fair trial and an impartial jury and an impartial judge under the 14th Amendment. Impartial jury, that's under the 6th Amendment. So mistake of fact is it's negates intent, right? It's a defense that negates intent. It's an affirmative defense. It negates intent. If it's specific intent, it doesn't have to it does, the misapprehension doesn't even have to be reasonable. There are cases, and I cited cases that were in my motions that I presented to the judge to consider earlier, but the judge didn't let me discuss matters of law during trial. But I raised it in my objections when just the prosecution and the defense were discussing the jury instructions that the judge was going to put, and I raised it as an objection. And he initially pretended like he was going to include mistake of fact. Then the prosecution makes a song and dance show of objection, right? And the judge goes ahead with his with the prosecutor's specious objection and removes mistake of fact. The same thing he did with self-defense. The prosecution speciously said, well, that I didn't raise self-defense in a trial, which is a lie, right? It's an absolute defense. I was in my home. I raised it. I stated it throughout, right? I demonstrated this as evidence, but in any event, the judge again excluded self-defense, excluded mistake of fact. And mistake of fact, there are cases that support this: State versus Lamson, the State versus Walker, State versus Vogel, State versus Navarro. There are different cases supporting mistake of fact. How that negates intent. It negates the required intent element in the intent to frighten second-degree assault, right, in Maryland. Then There was also another defense that I raised throughout the trial, but the judge continually tried to suppress it, right? He continued to try to suppress it. I brought an expert witness, and the judge did not let him testify. He was an expert witness. He's a professor of chemistry, brain chemistry, right? And drugs that deal with mental states and things like that. He's actually a professor of chemistry, and the judge did not let him testify, saying that I didn't provide him on the witness list as an expert testimony earlier on, that the months passed, and that was not my fault, because I was placed under duress to proceed pro se, right? It was the fault of my public defender. Just 7 days to trial, she had not, even though I provided all the lists of witnesses that I had, she didn't call it, she didn't subpoena any expert witnesses, didn't talk to anybody, nothing at all. And that was why I actually filed a motion to strike her appearance, to remove her as my attorney, because she was sabotaging my case, and she was constituting ineffective representation of counsel. So she was guilty of attorney misconduct and malpractice. So that was why I reported to the pretrial, judge James Bonifant, and he removed her as my attorney. And so I had cause to remove her, because she was providing me ineffective representation, and she was sabotaging my trial. She was only focused on one thing, that I should accept the plea bargain to return to Nigeria and never come back. When I'm an American citizen, I don't have any immigration issue. The state of Maryland, Montgomery County, without a warrant, without probable cause, filed trumped-up charges against me, assaulted me, and then, and I have a right to defend myself, right? That's my Sixth Amendment right, to defend myself, trial to show that I'm innocent because I was defamed. It violates my First Amendment rights. First Amendment protects us from defamation, by the way. So I had evidence of that I had been covertly drugged, right? I'd been covertly drugged on that day, and there's been evidence throughout that prior to that, I didn't have a mental illness. The state of Maryland psychiatrist determined I don't have a mental illness, right? Despite the numerous fraud upon the court. So there was this conspiratorial judicial obstruction of justice by Montgomery County Circuit Courts, including Judge James Bonifant, Judge Baby Berry, who wrongfully approved a fabricated and perjured emergency evaluation petition, in which it was ex parte. I had no notice, fabricated by an impersonator. I've done videos explaining that, which my family contended and disputed. So my family didn't know I'd been kidnapped under color of law, and that was what the police were coming to actually deliver, to execute an emergency evaluation petition. And Judge Michael McAuliffe suppressed this fact. I'm going to do another video talking about the Brady violations by the prosecution and by the police. But right now, again, like I said, I'm focused on the faulty jury instructions. So the suppression and elimination of the intoxicating drug, right, that negated mens rea or guilty. The guilty mind. So intent, like I said, is a requirement in intent to frighten assault in Maryland. It's a second-degree assault. So intent means a guilty mind, that the defendant had a frame of mind sufficient for him to form the crime, right? That he intended to commit a crime, right? So not just the action, actus reus. So Judge Michael McAuliffe and the state attorney misrepresented intent to frighten as a general intent crime, not a specific intent crime. So a general intent crime dilutes the burden of proof for the prosecution, right? So that the prosecution doesn't have to prove a guilty mind, mens rea. They don't have to prove that. They just have to demonstrate the actus reus. So Judge Michael McAuliffe intentionally misrepresented the intent as, the action, that the circumstances, the thing, my actions, what I did, right? That was sufficient to demonstrate intent, right? Meanwhile, specific intent says that intent actually has to be mens rea, that I had a guilty mind. I intended to commit that crime, not just my actions, not just a voluntary action, right? So there are two elements of a crime. Actus reus, so that's a physical act, whether it's a threatening act. But if my intent was not to harm them, right? The state still has that requirement, the burden of proving that I intended to harm them, to cause them physical harm. So Judge Michael McAuliffe's jury instructions eliminated that requirement for the prosecution by misrepresenting intent to frighten as a general intent crime, which has a lower standard, right? It's almost can be conflated with strict liability. Strict liability does not have mens rea, it doesn't have intent. The intent element does not have to be proved by the state. An example of a strict liability crime is statutory rape. So it doesn't matter if the person who sleeps with an underage girl thought she was an adult, thought she was 20 years old, thought she was over 18. If a man sleeps with a 14-year-old, right, it doesn't matter, even if she gave him a fake ID saying she was 20 years old, but the reality is she was 14 years old. So he didn't intend to sleep with a 14-year-old. It doesn't matter. He slept with a 14-year-old. So his thinking, his intent does not matter, right? That's a strict liability law. So Judge Michael McAuliffe misrepresented that element of the crime by saying it was a general intent crime instead of a specific intent crime. I had to have, the state had a requirement to prove that I intended to harm, to cause the defendants bodily harm, right? That I intended to put them in fear of causing them bodily harm, injury, right? So the state never satisfied that standard. They never demonstrated that proof, that element of intent to frighten crime. That's because intent to frighten assault, that's because Judge Michael McAuliffe disingenuously, corruptly misrepresented intent to frighten as a general intent crime and not a specific intent crime. So those are aspects of the jury, the biased jury instructions that Judge Michael McAuliffe gave the jurors, which led them to actually coerced them to manufacture a wrongful guilty verdict. By the way, the deliberations went on for 2 days. So they had a hung jury, and he ended up forced an Allen charge. An Allen charge is a dynamite charge. Basically, he was forcing them, they have to agree to a verdict. He was forcing a guilty verdict upon them, that they have to have one guilty verdict. This was what he did. And they had gone home, they had seen, they'd done their juror misconduct as well. There was juror misconduct as well, evidence of this, and prosecutorial misconduct. I talk about this in another video. The prosecutor was seen convening with a juror. So that's prosecutorial misconduct and juror misconduct as well, since it influenced the decision of the jurors. So I've done other videos talking about the flawed jury instructions, and now at some point the jurors actually, on the second day, the jurors, even though they had a hung jury, right, after 2 days, they asked a question, right? They asked if the judge would, if one of them had experience working with people that were mentally ill, and they understood that these people did not have, could not form intent, mens rea, because if they were in a mental health crisis, and they asked, can they assume that the defendant was in a mental health crisis, which would mean they had no intent. The judge gave a response tantamount to no, because he had already misled them with his jury instructions, right? Eliminating that requirement of mens rea, guilty mind. and also he excluded that element of guilty mind, you know. So also you could also see his misleading jury instructions, because at some point they sent out a note asking about first degree assault. They thought that the defendant, that I was charged with first degree assault, when that was not the case. I wasn't charged with first degree assault, because he had allowed biased testimony from a police officer, Detective Park, who stated, he was making misrepresentations of the law, stating that when I held a knife, I'm entitled to holding a knife to self-defense in my home, because I was in my home, and there was an unlawful intruder that put me in danger of my life, and put me in fear of suffering imminent bodily harm. But this Detective Park said that when I grabbed a knife, that was first degree assault. And the judge did not strike that from the record. He didn't tell the jurors to disregard that. So that made an impression on the jurors, and they were asking about this first degree assault, believing that was what they were deciding on. So you could see the judge intentionally misled the jurors. The jurors are made up of lay members of the community. They don't know anything about the law. Many of them, and it was a very biased, prejudiced jury pool, because the public defender told me ahead of time that, look, the community in Montgomery County, right, they favor the police. They think very highly of the police, and her argument was that we should try to suppress all evidence of police misconduct, saying that it would not be favorable if I misrepresented, if I showed the police as perpetrating misconduct by falsely imprisoning me, by manufacturing a crime, by suborning perjury, by filing false police reports, by fabricating an ex post facto arrest warrants. So they fabricated things. One of the fabricated arrest warrant, after I had already been taken into custody, removed from my home, falsely imprisoned, assaulted, and removed from my home, and even dumped already in the hospital. They went to go and fabricate an arrest warrant and search warrant to be able to get into my home. So they lied that I was in a fight with my wife on May 16, 2023, and threatening to harm her, when I don't have a wife. May 16, 2023, I didn't have a wife. I was living alone. All a fabrication, right? So the judge knew this. He hid it. I was able to see it, and it was exculpatory evidence. I explained that in another video in which I talk about the Brady violations. In any event, I hope this is helpful. This is not legal advice. I'm just talking about how Montgomery County judges and judges in Maryland have been able to use biased jury instructions to wrongfully convict innocent black men in Maryland. And that's why Maryland has the highest incarceration rates for black men in America. My name is Olurotimi Osha. I'll keep you posted. Thank you.